All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Dallas Hightower, Ricky Sanchez, Avery Tienda. I have a note that, let's see, I have a note that says car trouble, and then also I have one that says July 11th at 9. Do you know what that means? It says Ms. Clark requested set for 7-11. Okay, that's a sanctions court hearing. So the court will reset cause number CR 22295, sanctions court hearing for Avery Tienda for July 11th at 9 a.m. Adam Nguyen. Oh, yes, that's going to be Zoom from the jail. Sorry. Okay. Joseph Parks. Joseph Leon Parks. Katie Wiggins. Katie Wiggins.
Your Honor, Mr. Smith, about 9:30, I believe.
James Weatherford. James Carroll Weatherford. Curtis Smith. Curtis Wayne Smith. No, just tell me if you're here. You're here. Okay. I'll call your case in just a moment. All right. Is there anyone who's here? Your name's not being called? Your name? All right, Mr. Joyner. I believe you were on last week's docket. Or, I'm sorry. Yeah, it felt like last week. We've had a day off since then, so it felt like last week. Yes, ma'am. I'm going to call you up in just a moment and get you reset. Have you met with Ms. Abraham and done the paperwork yet? All right. Okay. Finish that and then I'll call you up. All right, I'm going to bring the jail in and we'll do the plea on Mr. Nguyen.
Oh, there we go. Okay.
Good morning.
Yep.
Good morning, Mr. Castle. Can you see and hear me okay?
We can. Good morning, Your Honor.
Good morning. Excellent. Thank you. All right. This is cause number CR 24-60, State of Texas versus Adam Ton Than Nguyen. Mr. Nguyen, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Is your last name pronounced Nguyen or Nguyen?
Nguyen.
Nguyen.
The G is silent.
Gotcha. Nguyen. All right. All right, Mr. Nguyen, a few questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jason Castle. Are you pleased with Mr. Castle and the work he's done for you?
Yes, sir.
Do you understand everything that you have read and signed today that's part of your plea agreement?
Yes, sir.
Do you have any questions before we go forward?
No, sir.
Mr. Castle, do you believe Mr. Nguyen to be competent? And if so, have you explained to him his rights regarding this case and believe that he's entering into this plea intentionally, knowingly, and voluntarily?
I do to all those questions, Your Honor.
All right, Mr. Nguyen, I see here that you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance of penalty group 2 or 2A in an amount greater than or equal to 400 grams. The range of punishment for a first-degree felony is not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice, that is prison. And
Your
also,
Your Honor, if I may, over 400 grams is going to be 10 to life with a fine not to exceed 100,000. And we've made a special notation on the paperwork as such.
okay, thank you. So this is one of those hybrid. Okay.
Yes, it is.
So not less than 10 and a fine not more than 100.
Correct, Your Honor.
All right, thank you. All right, let me repeat that, Mr. Nguyen. All right, so the range of punishment for a first-degree felony under this offense is not less than 10 years confinement in the Texas Department of Criminal Justice or more than 99 years or life confinement and an optional fine not to exceed $100,000. I see the plea agreement in your case is that upon your plea of guilty, the state's recommending that your punishment be assessed today at 10 years confinement in prison with a $1,500 fine, restitution of $180, and your time to be concurrent with your Gregg County sentence, whatever that may be. Do you have any questions about that plea agreement? Is that what you understand it to be, Mr. Nguyen?
No, sir, I have no questions.
Is that what you understand?
Oh, yes, sir. Yes, sir. I'm sorry.
Okay, that's fine. And you will be receiving 11 days credit toward your sentence for the time that you have spent in this jail waiting for this plea agreement today. Okay. All right. So let me ask you, Mr. Nguyen, how do you plead to manufacture or delivery of a controlled substance in penalty group 2 or 2A greater than or equal to 400 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Castle, any objection to the stipulation of evidence?
No, Your Honor.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further.
Anything further from the defense?
No, Your Honor.
All right, court's going to review the evidence. All right, upon the court's review of the evidence, the court finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation of the state today. Court hereby convicts Adam Ton Than Nguyen of manufactured delivery of a controlled substance, penalty group 2 or 2A, greater than 400 grams. The court assesses punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court also assesses a fine of $1,500, restitution of $180, court cost of $290, and reimbursement fees of $70. Court orders that this sentence run concurrent with the defendant's Gregg County sentence. And just because I know that the Texas Department of Criminal Justice is specific with their judgments, I'm not sure that it wouldn't be in the best interest of the state and Mr. Nguyen to have that Gregg County sentence number embodied in the judgment. So there's a reference. I'm not sure unless he's only got one sentence. Mr. Castle, how do you feel about that?
I'm happy to provide that if the court will give me just a moment.
And I think it would also be wise to say Gregg County, Texas, so that Texas Department of Criminal Justice is not trying to figure out which Gregg County and what the sentence is, that they'll have a specific reference. Court's also going to award Mr. Nguyen 11 days credit towards his sentence for the time that he has spent in jail on this cause.
So I have 52-274A.
52-274A.
Correct, Your Honor.
Is there any hyphens in that, or is that just all one?
Well, actually, hang on, I'm sorry. There was a couple different cause numbers, and I'm sorry, Judge, I may have given the court the wrong one. It's actually 276A, Your Honor.
52-276A.
That's right, Your Honor.
All right, now state if you would amend the judgment to reflect that the time to run concurrent with Gregg County, Texas sentence in cause number 52276A.
Yes.
All right, Mr. Nguyen, You hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with jail staff there to be fingerprinted, and if there's jail staff's not in there, we'll get jail staff in there. Once you're fingerprinted, then you'll be taken into custody and they'll execute the sentence. Do you have any questions, sir?
No, sir.
All right, anything further, Mr. Castle?
No, Your Honor.
All right, thank you, Mr. Castle. We'll get the front page of the judgment. We'll go ahead and fingerprint him on the back page, and then we'll get the front page of the judgment fixed. And if you need a copy, just let the state know.
Thank you, Your Honor, and I'll bring our signed paperwork over to the courthouse here momentarily.
All right, thank you, Mr. Castle.
Thanks, sir.
And Mr. Castle, is there any jail staff in there to take a fingerprint?
They, not in the room right now, but they did tell me that they would take care of that when we were finished.
Excellent. If you'll just remind them, I appreciate it.
Yes, sir.
All right, thanks, sir. All right, do we have any counsel in the courtroom that's ready?
Yeah.
This is on Ms. Wiggins, correct?
It is, Your Honor.
All right, let me go ahead and call the case. This is cause number CR 15-123, State of Texas versus Katie Lynn Wiggins. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, we were set, that's not today. I received a phone call about 6:30 this morning from Ms. Wiggins' mother. Called her back at 7. Apparently she arrested by Henderson County for pursuant to a search warrant. I think she's not broke in, I think confirmed investigators. She has been arrested. So that's all I know.
Okay.
She's gonna be broken in.
All right, court will reset Ms. Wiggins' motion to revoke. You're available on July 30th. I know that might not be enough time to figure out what's happening in Henderson, but I don't want to set it out too long.
Understood. Yes, sir. I do have a plea that afternoon in Athens, and I guess you might be on the jail docket depending on what happens. I can make it work.
Okay,
July 30th?
July 30th at 1:30. We'll just go ahead and set it for 1:30.
Yes.
And if she ends up not in custody between now and then, if you'll just notify Ms. Taberham, we can get that moved if we need to.
Yes, sir.
Who did? I know. Yes, thank you, Mr. Schmidt. Mr. White, are you ready, sir? Okay, sure, no problem. Dallas Hightower. Come on up, Mr. Hightower. Ma'am, you gotta stay back. Mr. Hightower, this is cause number CR 23-217, we were set for a sanctions court hearing today. However, the Community Supervision Probation Department has filed a warrant, and a warrant is active for your arrest. So we're going to take you into custody at this time. All right. So if you'll come on around here, stand by this small table. Just come right over here, sir. It's fine. Right there with that small table. Ma'am. Mr. Schmidt, you don't you're not representing him, or oh, okay. It's a motion to revoke warrant. Morning, sir. We were thinking the same thing.
Hey.
Ms. Sanchez. This is cause number CR 16-149, State of Texas versus Ricky Lee Sanchez on the motion to adjudicate warrant in hearing. Court had Ms. Sanchez set previously, and we reset today for status on compliance and possible dismissal. Any announcement from the state?
Right, this time statement withdraw. And also.
All right, you don't have any objection to that, do you? None at all, right? All right. Court finds that Ms. Sanchez has completed her term of community supervision is in compliance. Court hereby grants the state's motion to withdraw the warrant and terminate the community supervision of Ms. Sanchez. Are you going to have that form filed today?
Yes, sir.
If you can go and do that, do you want to wait and get a copy, or do you want to get a copy some other way? It'll be filed with the clerk's office. Well, I won't mail it, but you can either stay and get a copy today, or you can come back at a later time and speak with the clerk's office and then give you a copy. What do you want to do? Do you want to wait, or do you want to? All right, then you're free to go.
Thank you.
You're welcome. Ms. Joyner. Mr. Schmidt, do you have that cause number before you? 127. So much feedback. All right, this is cause number CR 20-127, State of Texas versus Alicia Joyner. And Ms. Joyner has a motion to revoke warrant, is that correct? Or a motion to revoke? Setting. All right, the court finds that Ms. Joyner was previously scheduled this week, had failed to appear. The court had indicated the issuance of a judgment not signed alias capias. The court is withdrawing that at this time based on her appearance today. And the court has found Ms. Joyner to be indigent on the review of her application for court-appointed counsel. Court has appointed the Honorable Richard Schmidt to represent Ms. Joyner. The last time I said that I didn't think you would be ready and wanted to reset, you resolved the case as soon as I said it. So I'm not going to presume to know what to say anymore on that. So any announcements, Mr. Schmidt? All right, you want to reset to the July 30th? That's the next contested docket. Not saying that it has to be contested, but we can set it on that date. All right, court sets Ms. Joyner for July 30th at 9 a.m. And Ms. Joyner, once you sign, you're free to go. Remember, you're still on community supervision. So if you don't report or if you violate, the state could amend your amend their motion and bring additional allegations against you. You're welcome. Is Mr. Manning here? John? Richard? Did you? You ready?
Yes, sir.
All right, you ready on Curtis Smith? Curtis Wayne Smith, CR 2464, CR 2465. All right, Mr. Smith is set for pretrial today. Go ahead, Mr. White.
Your Honor, I'd like to, read. And also, second, takes a motion to adopt those motions as well. I am asking for another retrial, and because, and it's totally my fault. The film that is up on the display, I couldn't get it to work, and I haven't even told the state at this point. And, I don't believe they have any problem with me asking for it. Retrial.
Any position state?
No, Your Honor, we'll get Mr. White to make sure that we get a hard copy of whichever video was not working.
And like I said, Judge, I didn't even let them know.
Okay.
It wasn't their problem.
Remind me, Mr. White, do you prefer Tuesdays or Thursdays?
Let's try Tuesday.
You want to do July 9th?
I will not be here Tuesday.
We'll try July 2nd.
Second.
That's 2 weeks. That's 2 weeks.
I think I can do my second.
All right, court sets Mr. Smith for additional pretrial hearing on July 2nd at 9 a.m. Once you sign and get your notice, Mr. Smith, you're free to go.
Thank you.
You're welcome.
Okay.
You may. All right, we are on the record of cause number CR 23-194, State of Texas versus James Carroll Weatherford. Court knows that Mr. Weatherford has already appeared before the court and entered a plea of guilty. The court followed the plea agreement recommendation of the state. The court, however, held the issue of restitution over for determination at a subsequent hearing based on the request of the defendant that is set today. Court finds at this time that Mr. James Carroll Weatherford is not present for the restitution hearing. Mr. Schmidt asks his counsel, do you have any information on Mr. Weatherford or his whereabouts? All right. Does the state have any information on Mr. Weatherford's whereabouts?
Your Honor, we do not, other than, a very brief conversation with probation that they've had some trouble in contact as well. We do not have any information.
All right. Is there any objection from the state, from the court continuing this hearing for the determination of restitution as a part of Mr. Weatherford's? And I believe that Mr. Weatherford was placed on community supervision in this court, correct, Mr. Smith? Any objection from the state going forward for the court to determine the restitution?
Yes, Your Honor, state would object, our witnesses are here today, they're having to take time out of their schedule off work.
Well, no, so you don't have an objection as to us going forward. You would have an objection as to us resetting.
Yes, Your Honor.
Right. But there's no objection from the state from us going forward today. Okay,
Sorry.
no problem. Mr. Schmidt, as counsel for Mr. Weatherford, any objection to the court considering the evidence on restitution without Mr. Weatherford being present today?
Should be restitution. And prior disclosure, we also at the time we stipulated to the evidence which they intended to work. So we would have objection. About a year.
Thank you, Mr. Schmidt. All right, the court finds that James Carroll Weatherford appeared before the court, entered a plea of guilty. The court placed him on community supervision at a previous setting and gave him notice of the restitution hearing in open court. Court finds that Mr. Weatherford has failed to appear to participate in the hearing. The court's going to find at this time that Mr. Weatherford, although not on bail before this court, has voluntarily absented himself with regards to the restitution hearing as a component of his community supervision. The court finds that on that voluntary absence without additional information from either the state or the defense that Mr. Weatherford cannot be here today, the court is going to grant the state the opportunity to enter in their evidence and for the defense to have an opportunity to cross-examine or object to that evidence outside the presence of the defendant. All right, state, do you have any evidence to present?
Yes, Your Honor. We have it's a page from the report that was submitted in evidence that gives a breakdown of restitution. On the page, it is total at $12,040. I've offered it as State's Exhibit 1.
And Judge, I will previously stipulated the state said that some type of plea that to the answer.
All right, State's Exhibit 1 is admitted. Thanks, sir. All right, anything further from the state?
No.
Anything further from the defense? All right, at this time, the court finds that the evidence before the court has established and is proven that the restitution in cause number CR 23194 is in the amount of $12,040. The court hereby orders James Carroll Weatherford to pay that restitution amount to the victim in this case and for it to be included as a condition of his community supervision.
And Judge, I would
Names like that. Right, and, you go ahead and one, and trial.
Do you have those names handy? Mr.
Yes,
Arthur?
sir. I'm waiting for first names. Your Honor, co-defendant's name is Terry Lorenzo Johnson. He's currently set out the trial. I don't recall the cops on the docket. I think it's just.
All right, then the court orders that restitution in the amount of $12,040 be paid joint and several between defendant, in this case, James Carroll Weatherford, and co-defendant Terry Lorenzo Johnson. And court orders that joint and several restitution as a condition of community supervision. All right, anything further from the defense?
No.
Anything further from the state?
Nothing.
All right, there being nothing further, then the court, having made its orders, hereby adjourns in this case. All right, that completes this morning's criminal docket. We will stand in recess until 1:30.